Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina, and today's topic is, What's My Message? Government Relations and Antitrust in the EU. Government relations and lobbying can be critical components to antitrust and merger control review in many jurisdictions. In this episode of Our Curious Amalgam, we discuss the role, benefits, and potential pitfalls of government affairs and lobbying efforts, with a particular focus on the EU. Joining me today is my co-host, Matthew Hall. Hi, Matthew.
Hi, Christina. It's good to be back.
Welcome back. So tell me what we're talking about today.
Well, as you said, we're discussing the important topic of how to get your message across to antitrust and merger control regulators. Cases are not all about the legal and economic analysis. Cases can be very political, and customer and competitor reaction is, of course, very important to regulators as well. Therefore, the message matters, and that's what we're going to discuss.
And who's our guest today?
Well, we're pleased to welcome Claire Harris. Claire is the founder of Claire Harris Antitrust, working in London and Brussels. She's been a competition lawyer at international law firms and also worked at the UK OFT, now the Competition and Markets Authority, as well as at Visa Partners, FTI Consulting, and currently also at Comber Associates. She has significant experience in government relations or lobbying in Brussels and London across a range of antitrust and merger control matters. And she informs me that she will soon become a DPhil candidate at the University of Oxford here in the UK, researching the concept of fairness in EU competition law and policy. Hello, Claire.
Hello, Matthew. Lovely to be here.
Thank you very much for coming on. We've referred to government relations or lobbying. I know that Brussels, along with Washington, D.C., is probably the world center of this. Can you just tell us briefly what the GR scene in Brussels is across all aspects? It's not only antitrust, is it? But it's a big scene there.
Yes, it's a very big scene in Brussels, and I suppose from my point of view and what we do in antitrust cases, I prefer not to call it lobbying. I think it gives it a sort of a different meaning in people's minds as to what we actually do. But government relations generally is a big deal in Brussels. Not only are there lots of consultancies offering services to companies, but there's lots of actual companies who've got headquarters or certainly very big offices there in order to be able to have access to the decision makers and policy makers within Brussels. So I would prefer to call what I do strategic communications, because it's really to do with, as you said before, Matthew, actually getting the right message across to the right people at the right time. And so when I started off, I came out of private practice. I started off with, as you mentioned, a Visa Partners. It was just being set up as a sort of specialist boutique agency to lobby in competition cases. That was in like 2007. When I was there, I co-authored a piece on hows and whys of lobbying with Brandon Mitchener for the Concurrence magazine, because it was really quite new at the time that we were trying to do strategic communications around competition cases. It always been sort of viewed as being a bit of a no-no. And then 6 years later, I joined FTI Consulting, obviously a much bigger consultancy with a global reach. I think generally in Brussels, although there's lots of consultancy, there's few that build their business around competition cases, and Visa was probably an exception to this rule. Usually they tag it onto their main areas of focus, whatever that would be. It could be because they're particularly interested in financial services or health, or they work for various associations. And the reason why few public affairs consultancies kind of hang their hat on competition work is because the work's quite cyclical, and so that means it's different to keep it as a sustainable practice. And I suppose around about 2013, when I joined FTI, there were a number of large players such as FIPRA, APCO, Brunswick, Burson Marstella, Edelman, who would engage in lobbying on competition cases. And there were then the boutiques, and then there were also some law firms had their own public affairs teams, which was DLA Piper and Freshwheels mainly. Over the years, the constituency has changed a little bit because the number of individuals have either jumped ship or moved on or moved around. And there have been new entrants as well, such as Canberra Associates, who I've been working with recently. Reed Pedersen has also started to come into doing a bit of competition work. And then also with bigger teams at law firms, such as Covington, and as well as some consultancies or law firms hiring ex-DG Comp officials. You know, for example, FTI hired Sir Philip Lowe at one point, who used to be the Director General for Competition. But anyway, sorry, this is going on quite a lot.
I remember that hire.
Yeah.
There is the EU lobbying register, isn't there? Does that give us an indication of how many people there are doing the work? At least, I mean, they won't all be in Brussels, I guess, but not everyone will be registered, I assume. But does that give us some idea of how many?
There are some rules over getting on the register, obviously, of requirements to be on the register, and that's become stricter over the last few years, to the extent that I've been in a situation when I've heard of people being refused meetings with DG Comp officials because they haven't been on the register. And it gives you, I mean, if you were to browse through it, you would see the extent of the number of agencies, I suppose, who are either based in Brussels or elsewhere. But what you don't really see is the volume of competition work which is represented there, because you don't have to declare it.
Yeah, and of course, lawyers doing pure legal work, a lot of that is really, if you like, lobbying your case and writing submissions. That really is a type of lobbying, I guess. But let's not call it lobbying. You told me off already. We'll call it strategic communications, or at worst, government relations. So you mentioned the competition field, of course, and it being cyclical. What type of cases, or what are the main focuses of activity within competition that are being the subject of strategic communications? Is it all mergers, or is it other things as well?
No, it mirrors what the law firms are catching in their nets, I suppose, because it's usually law firms who suggest to clients that it would be good to get strategic communications people on board. Sometimes you can get directly appointed by a client, but it's not usual. And sometimes somebody like me might spot an opportunity and kind of, reach out directly to the client. But it's really a question of watching what's going on and building relationships with law firms in order to be able to get referrals. So in much the same way as economists do. So what's available is what we get. There's a constant throughput of merger cases, clearly, especially if the legal team identifies a phase 2 risk, or if there's a particular reason that a phase 1 clearance is needed. So I have worked on a lot of merger cases, usually for the buyer. But sometimes a change in rules or the introduction of new procedure can throw up things. So, for example, there was a time when the cartel structure was being changed. There was a new settlement notice being brought in, a new leniency notice, and then an inability to pay angle. So that if companies were facing financial difficulties as a result of getting the possibility of getting high fines, they could go through this inability to pay process. But because all of those things were fairly new and hadn't been tried and tested, there was actually more of a need for people like me to really reach out to DG Comp. And that's why I say it's a communications role, because it was a question of really mediating and carrying back to the client what needed to be done, as well as listening, as well as taking a message to DG Comp. So sometimes it can be a two-way street.
So that'd be more of a generic type of situation. I'm going to ask you to talk about how it works, particularly in merger control and then antitrust cases. But I think it'd be quite interesting for people to hear some things which are in the public domain, not necessarily that you've done, but, or of course you're welcome to talk about those as well, but some kind of examples of things that we might be aware of where it was clear that strategic communications was going on, and how that might have, influenced or not influenced what ultimately happened in those cases.
Right. So before I get there, I should also have said that the antitrust cases are probably the holy grail for consultants, as because they're going to last for years. You only have to look at things like the Google case, and lasting 8 years or so. So those sort of things obviously are what consultants would like to get their hands on. But on a more basic level, I mean, I think the example I'd like to bring to your attention, I think, is Qualcomm. It's not a case I worked on, but I have to say that they did a remarkable job of carrying out their government relations work in Brussels, both around there was an EU antitrust case, and then there was also a proposed communication from the Commission on standard essential patents. And they made sure that they were absolutely everywhere. I mean, that they had speakers on conferences, that they were ever present. They were very much involved in lobbying in the EU Parliament, which is not something you would normally do on a antitrust case. And as well as being around the Commission, and even to the extent, and I don't know whether this might just be a bit apocryphal, but I think just before that communication on SEPs came out, it seemed to me, at least, that every bus shelter around the Berlaymont had a poster in it for Qualcomm and how great it was. So. Now, obviously, that sort of.
You think that was part of the?
I don't know.
Part of it may not help if a Commission official is sitting there in the rain and waiting for the bus. That may be a bad thing. The bus never comes.
It was just really noticeable, and I don't know whether I was more in tune with what was going on at that time than other times. But obviously, those sort of things can backfire badly, and obviously over lobbying is something which the Commission hates, which DG Competition absolutely abhors. So you have to get a balance. But I mean, I suppose a more typical example, as I said, it's difficult to work on these long antitrust cases, mainly because actually now companies are tending to want to retrench their communications and take it back to normally the US to manage it from there, rather than have it dealt with by people on the ground in Brussels, which I think is a mistake, but anyway, that's what they seem to think. But on merger cases, which is as we talked before about being sort of the stock in trade, you can get good results by just being very, very methodical and working well with the legal team and making sure that everybody keeps on message, and that you do your outreach to the people that you need to speak to at the right time. So, and that you handle the political elements sensitively well. So, for example, I worked on, it's a long time ago, but it was Sony ATV EMI, and it ended up being a phase 1 clearance, which was just what we wanted. But there were sensitivities about it because of EMI being like the home of the Beatles back catalogue, and also because of the Michael Jackson family involvement in it as well. but anyway, you have to make decisions as to which elements of the case you're going to play up and which you're going to downplay and which you're going to focus on. It in much the same way as the lawyers are doing it in the nuts and bolts of the case. You have to also make sure that you reflect those, but perhaps in a slightly different way for consumption by the media. For example, I listened to your podcast with Leah Nyland. It's very important. My role obviously involves quite a lot of contact with journalists in order to be able to make sure that we handle everything smoothly on that side as well.
Yeah, that was one where she's at. That was a very interesting one where she's at Politico, formerly MLEX, a journalist in the sector. Okay, so maybe let's look at merger control. Certainly, an economist will say it's never too early to involve the economists in these merger cases. Presumably, from your point of view, just take us through the steps of how it might work with involving the strategic communications people. Presumably, you'd say to the lawyer, look, yeah, it's never too early to involve us as well. But ideally, how would it work for you, and what kind of steps would you take, in a fairly difficult case, starting from the beginning?
There have been cases where I've been brought in right at the very beginning, which is great. It's by far and away the best. Obviously not before the economists. The economists normally get in first, but certainly not long after. And one such case was Bull Wrexham. So we worked on that. So it's really good to be able to understand the case. And I obviously, coming from a legal background and having worked on cases myself, I think it made it easier for me to be able to understand what the legal issues were, market definition issues were, and all this sort of stuff, to be able to then advise on what should be done. And because the merger regime in the EU is under a strict timeline, you can sort of map out what you need to do in the first phase, and then if it goes to second phase, what you need to do in the second phase to build up towards the eventual decision, bearing in mind it's an administrative process, and it's I would call it a political decision-making process, because all of the commissioners are involved in it at phase 2. So the usual steps would be to, one, identify what the issues are, the main competition issues, and how they're going to be addressed, work with the legal team on that. And then I suppose, secondly, it's working out where you would need to engage with stakeholders and or media, at what points you would say it, and what your messaging is going to be at those points. What you particularly need to do around remedies discussions, because that's where things get hairy. Because at that point, the parties will be really, really dead keen to get the deal done, and that's very difficult to kind of manage expectations, I think, with the client, as well as managing expectations of the journalists who will be following it, who will be wanting to probe for information and can get very insistent with in this particular, not in this case, in the Energizer Spectrum case, they kept on bothering, in inverted commas, the client, who didn't like that very much at all. So those are the steps that you would take, as well as then working out, because as I said before, because the system is designed to go out to competitors and customers, obviously it becomes something which is much more of a public debate at that point. And so it's important to identify any third parties who are going to be real opponents, and also work on any third party potential endorsers who can speak up on behalf of the parties to support the case.
And what about other jurisdictions? Many of these cases you mentioned will have been filed all around the world, US, but also elsewhere. What other jurisdictions stand out, apart from the US really, but what other jurisdictions stand out for you as really the places where similar activity is needed, or is it? And would you then liaise with presumably local strategic communications people, because they know the bus stops and what have you in their area?
Yeah.
So how would that work?
Yeah, it is sometimes needed, but it's not as needed as you think. And what you might need to do is not necessarily engage other public affairs consultancies in other jurisdictions, but you might need to have contact otherwise with. I'm thinking of for example, the French or the German competition authorities often have been authorities that have been important to reach out to in terms of the cases which were being fought in Europe or determined in Europe. So that's a possibility. I don't think I've ever engaged another consultancy to do the work, except for the there was a Hutchison case in Italy, and that involved legal teams in Italy and also consultancies being able to do work directly in Italy. So yeah, it is possible to be done, and obviously in the US you would, if there were any issues in the EU. There's likely to be issues in the US as well, and you would have to liaise with your counterpart there.
You mentioned antitrust cases, or so non-merger control cases. You mentioned Qualcomm. What are the differences between those types of, and also you mentioned those are the holy grail because they last for so long, which suggests there's no timetable. So what is the difference what are the key differences between strategic communication? It's maybe difficult to generalize, but strategic communications on those types of cases as opposed to the merger control cases where there are, of course, the fixed timetable, at least in the EU.
I think it's a question of it being potentially much broader. So when I was at FTI, for example, Google was already a client on tech issues, and then we were engaged when the SO was adopted. So when you're facing something like it's an enormous undertaking for everybody, and everybody's completely bogged down with the getting to grips with the substance of the case. I can't really say too much on what we did about the messaging, but it's important that you have to pace everybody, because you can't be working at the same speed as you do in a merger case, because potentially it could last for years and years. So you have to be able to build in some sort of longevity of the messaging, and build in some more resilience amongst your third-party endorsers, I suppose, is the way I would put it.
So people need to be in it for the long haul.
Yeah,
I guess is what you're saying, which I think applies to the legal team and the clients as well, unfortunately. So what about, like many things, Brexit may have had an influence on what's going on in this world. Maybe early days or relatively early days, but have you seen anything different?
The CMA's been recruiting like mad, particularly state aid experts. I suppose because they think there's going to be an increase in their workload, and there will be, won't there? There's going to have to be, because there's going to be concurrent investigations in the UK as well as in the EU. So I expect them to define their role in merger cases over the next year. And I suppose the question that everybody's asking is, well, is the policy in the UK going to diverge from EU case law? And I suspect it might, because particularly if it spots any specific effects in the UK, or part thereof, in fact. So yeah, I think there will be changes, and it's early days, but I think this is, in a way, it's something which I think the CMA will relish, It'll, yeah, I think it will. It's a different organisation from when I was there, many years ago. It's much more focused on advocacy for itself and competition advocacy in that way. And I think it will, put its best foot forward to do a good job, but not necessarily follow the EU to the letter.
Great. Well, Claire, really appreciate your insights today. I think you've presented some very good examples of effective lobbying and government affairs efforts and less effective instances of such efforts. Before we let you go, however, we always ask all of our guests a few questions just so we can get to know you a bit better. The first question is to tell us something about yourself that we wouldn't know about you if we only knew you professionally.
Right. Well, this is... oh God, I don't know if this is going to get me into trouble, but I grew up in northwest London, in Harrow, and I used to go to the girls' grammar school. We used to go out with the boys from the local secondary modern, and one of those boys was a boyfriend of mine, and he later became a drummer with Adam and the Ants.
Wow. We'll reach out to Claire to get backstage passes.
Not when I still knew him, unfortunately, but I went to university and studied law, and he went and joined Adam and the Ants.
That's a great story and throwback for many, many years. So yes, most folks would not know that. And Claire, you've obviously had a long and storied career. Do you have advice for younger attorneys or individuals who are looking to do what you do?
I think I think the thing to do is to be true to yourself, really, and to do as much studying as you can, to not be put off, because I think there's still a sense in some law firms, at least, that women aren't treated in the same way as the men. And I think you just have to stick to your guns and show how good you are. And be prepared to kind of step outside of your comfort zone. I think certainly when I went over to doing consultancy work, I was terrified of it, to be honest. I didn't know what I was doing for the first 6 months. And, you need to be able to think that you can do something and do it.
Great. So now our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
Claire, so I'm going to ask you to pick a number 1 through 25.
13.
13. Okay. If you couldn't live in the country that you live in now, what country would you like to live in?
America. United States. I'd like to live in, and to be even more specific, I'd like to live on the west coast of the United States, probably in the San Francisco Bay Area.
I was going to say for like a change in weather, but San Francisco isn't too different from that perspective. So have you ever lived abroad in San Francisco or elsewhere for a period of time?
I've never lived in the States. I've lived in Brussels, obviously, for years, but I don't think I'd ever want to go anywhere else in Europe, particularly forever. But the States, I would.
And what's the love for San Francisco?
Just like it. Just like the look of the place, like the feel of the place.
I think many, many people agree with you on that one. So, well, Claire, thank you again for joining us on our Curious Amalgam. And to our listeners, thanks for listening to this episode, and we'll catch you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.